Learned senior counsel appearing for the petitioner has argued before us that borrower company has availed the loan in question by creating equitable mortgage of the entire area of plot bearing Khasra Nos 692 and 693 in favor of both the financial corporations by depositing title deeds of the land in question, and both directors of the company have stood guarantors for the loan by executing agreement of loans undertaking and bond of guarantee. The learned senior counsel has further argued that after the land in question being mortgaged and directors of the company having stood guarantor for the repayment of loan by executing agreement of loan undertaking and guarantee bond, if the company has defaulted in making repayment of loan and corporations have proceeded to sell the mortgage assets and in furtherance thereof have sold the mortgaged assets to the petitioner in public auction under section 29 of the State Financial Corporation Act 1951, and the said auction has been confirmed up to Honorable Apex Court, the assets so sold have vested in the petitioner with all rights as if transfer had been made by the owner of the property as provided under subsection under bracket 2 of section 29 of the act, and it is now not open to borrower company oblique guarantors oblique legal heirs of promoters oblique directors and even the financial corporations to claim any right in the sold assets by saying that Jaiprakash Dubey had created only lease right in the piece of land measuring 15,872 square feet for 30 years, and the borrower's company had mortgaged the same right to the financial corporations, and in the given situation petitioner has acquired the same right in the land. Para. The learned senior counsel has submitted that in the case in question transfer shall be deemed to have been made not only by the corporations but by the guarantor also, who has given his personal guarantee, and that guarantor being director and promoter of the borrower's company. The land so transferred shall be vested in the purchaser with full rights and free from all encumbrances. He has submitted that this was the reason that when value of the mortgaged assets was assessed by the corporations before putting the same to sale, the full market value of land measuring 15,872 square feet was taken into account, treating the land as freehold land and not as leasehold property, and was also sold at the same value. He has submitted that after selling the entire land, treating as freehold property, coupled with delivery of possession, and petitioner having enjoyed the same for considerably long time by getting its name entered in the municipality and regularly paying the taxes, it is now not open to corporations to say that they have sold lease hold rights for the residual period of lease in the land measuring 15,872 square feet, and ownership of the land still vests in the actual owner, to whom the land shall be reverted back after the expiry of 30 years period of lease. Over.